The Senate will come to order. Senator Zinzinger, would you please lead us in the pledge?
Thank you. If all the guests and my colleagues will rise, I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Majors, would you please take the roll?
Aguilar. Balmer. Baumgardner. Brophy. Cadman. Crowder. Grantham. Guzman. Harvey, Heath, Herpin, Hill, Hodge, John, Johnston, Jones, Kafalis, Kerr, King, Lambert, Lundberg, Marble, Newell, Nicholson, Renfro, Rivera, Roberts, Scheffel, Schwartz, Stedman, Talktrop, Todd, Uleberry,
Excused.
Zenzinger. Madam President.
Here. With 34 present, 0 absent, 1 excused, the Senate has a quorum. Motion to adopt the journal. Senator Marble.
Thank you, Madam President. I move the reading of the journal dated Monday, March 24th be dispensed with as approved and corrected by our most highly respected secretary.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The motion is adopted. Committee reports.
March 25th, 2014, Committee on Appropriations. After consideration on the merits, the committee recommends the following. Senate Bill 151 be referred favorably to the Committee on Finance. March 25th, 2014, Committee on Appropriations. After consideration on the merits, the committee recommends the following. Senate Bill 115 be amended as follows, and as so amended be referred to the Committee of the Whole, a favorable recommendation. March 25th, 2014, Committee on Appropriations. After consideration on the merits, the committee recommends the following. Senate Bill 161 be amended as follows, and as so amended, before the Committee of the Whole, a favorable recommendation. March 25th, 2014, Committee on Appropriations. After consideration on the merits, the committee recommends the following. House Bill 1100 be amended as follows, and as so amended, be referred to the Committee of the Whole, a favorable recommendation, with a recommendation to be placed on the consent calendar.
Senate Services.
March 25th, 2014, correctly printed, Senate Bill 167, Senate Joint Resolution 22. Correctly engrossed, Senate Bill 156, Senate Joint Resolution 20. Correctly revised, House Bill 1047, 1080, 1193, 1210, and 1274. Correctly re-revised, House Bills 1089, 1105, and 1254.
Message from the House.
March 24th, 2014, Madam President, the House has adopted and returns here with Senate Joint Resolution 20.
Committee reports.
March 24th, 2014, Madam President, the Committee on Judiciary has had under consideration and has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar and confirmed. Members of the Colorado Commission on Judicial Discipline for a term expiring June 30th, 2015, Yolanda Regina Lyons of Monument, Colorado, to serve as a non-attorney and occasioned by the resignation of Albus Brooks, appointed for a term expiring June 30th, 2017. Richard O. Campbell of Denver, Colorado, to serve as an attorney, reappointed, and Kathleen S. Kelly of Meeker, Colorado, to serve as a non-attorney, reappointed. March 24, 2014, Committee on Judiciary. After consideration of the merits, committee recommends the following. House Bill 1069 be postponed indefinitely. March 24, 2014, Committee on Judiciary. After consideration of the merits, the committee recommends the following. House Bill 1149 be amended as follows, and as so amended before the Committee of the Whole, a favorable recommendation.
Mr. Majority Leader.
Ready, Bill? You ready? Thank you, Madam President. I move we proceed out of order for a moment of personal privilege for the Minority Leader.
The motion is to grant the Minority Leader a moment of personal privilege out of order. All in favor say aye. Opposed, no. Ayes have it. Mr. Minority Leader.
Thank you, Madam President and Senator Heath. Folks, we have some very special guests here with us today. Live in the Colorado Springs area. The McCloskeys, who are president and wife of the president. Actually, you both co-own McCloskey Motors, I understand. At least that's what the commercials indicate. Awarded the National Quality Dealer of the Year and the second time to win the Quality Dealer of the Year in Colorado. Ann is from Denver. Joe is from Pueblo. I guess that makes you natives. This is a very prestigious award. It's awarded to the dealer who is committed to quality, excellence, outstanding customer service, and making their community a better place. Each year, the award is becoming more coveted as standards for excellence are raised. And when you think about the number of folks that compete with for this, Joe is telling me 37,892. It's almost like getting elected, right? One of 37,800 plus dealers across the country. They have 2 sales locations, 2 service locations. They employ 63 people. It's funny because there's 69 people here with them. They sell nearly 1,500 cars a year. Are you hiring? Because that's pretty good volume for a former car salesman. They service nearly 3,500 vehicles a year. And in one of our own recent tragedies, they personally raised over $40,000 and donated to some folks to help them in the Waldo Canyon fires. They are a significant part of our community. This is our opportunity to recognize them, thank them, and wish them well in the future because they are doing great things for our community and for the state. Let me share the tribute that we had prepared for them. The Senate of the Colorado Legislature convened in the second regular session of the 69th General Assembly hereby extends heartiest congratulations and commendation to Joe McCluskey on the occasion of being awarded National Quality Dealer of the Year. We recognize your exemplary care and service to the Pikes Peak region through McCluskey Motors. Being recognized by the National Independent Auto Dealers Association is an incredible feat which brings national attention to our great state. We are thankful for you and your dealership's dedication to making our region and state a better place, given this 25th day of March 2014 in the Colorado Senate. Congratulations. Thank you for taking the time out from your busy schedules to join us today, and we are thrilled to have you here to recognize you for this amazing honor that you've brought to your company and to the state of Colorado. Thanks for being here, Joe and Ann McCluskey. We also have sharing the time here with them, besides the 69 people on their 63-person staff, the president of the Colorado Independent Auto Dealers Association, as well as the executive director. We have David Cardella. Isn't that interesting? President of the Auto Dealers, his name is Cardella. And Todd O'Connell, thank you for joining us, and thank you for the recognition that you were able to help bestow upon Joe and their entire operation and their staff. Thanks for being here today as well. Thank you.
Introduction of resolutions and memorials. Mr. Majors, would you please read the title to HJR 1010?
House Joint Resolution 1010 by Representatives Singer and Buck and Senators Nicholson and Renfro concerning the recognition of flood recovery efforts throughout the state.
Mr. Majority Leader.
Thank you, Madam President. I move House Joint Resolution 1010 be laid over till Tuesday, April 8th.
For the motion, all in favor say aye.
Aye.
Opposed, no. Ayes have it. HJR 1010 will lay over until April 8th. Mr. Majors, would you please read the title to Senate Joint Memorial 2?
Senate Joint Memorial 2 by Senator Toktrop and Representative Lebsaw concerning memorializing former Senator Eldon W. Cooper.
Mr. Majority Leader.
Thank you, Madam President. I move that Senate Joint Memorial 2 be laid over till Friday, March 28th.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. Senate Joint Memorial 2 will lay over until Friday, March 28th. Introduction of bills.
Senate Bill 168 by Senator Lambert and Representative May concerning the salary structure for compensating teachers employed by the Colorado School for the Deaf and the Blind.
Education.
Senate Bill 169 by Senator Lambert and Representative May concerning information that the Office of Information Technology is required to provide to certain members of the General Assembly in connection with its annual budget requests.
Business, Labor, and Technology.
House Bill 1057 by Representative Navarro and Senator King concerning the Colorado Fraud Investigators Unit.
Finance.
House Bill 1282 by Representative Pabon and Senator Toktrop concerning the specification of what materials may be provided in a language other than English by an insurer to a customer.
Business, Labor, and Technology.
House Bill 1291 by Representatives McLaughlin and Humphrey and Senators Renfro and Toctop concerning authorizing a charter school to employ a school security officer by contract to carry a concealed handgun if the person has a valid concealed carry permit.
Education. Third reading of bills. Mr. Majors, would you please read the title to House Bill 1193?
House Bill 1193 by Representative Salazar and Senator Cafalas concerning requirements governing the imposition of a fee for the research and retrieval of public records under the Colorado Open Records Act.
Senator Cafalas.
Thank you, Madam President. Good morning, colleagues. I move House Bill 1193 on third reading and final passage.
Any discussion? Senator Cafalas.
Thank you, Madam President. Colleagues, before we take a vote, I just want to reinforce and remind folks what the purpose of this bill is. The bill is basically about requiring that any government custodian that imposes a research and retrieval fee to develop a written policy and establishes a maximum hourly fee that can be charged. This bill is about providing the public with certainty. We talk about that a lot here. Oftentimes when people are trying to access public records, they're not sure what they're getting themselves into. And when we speak about research and retrieval fees, across the state we have seen quite a bit of variability. And what we are trying to do is create some certainty with House Bill 1193. This bill is about clarification. It means that CORA policies must be posted in a public place on counties or state government websites. It means that the first hour of research and retrieval is free and that the charge cannot exceed $30 per hour. There were various court decisions that were established over the years, and what we are trying to do here is basically put one more piece of the puzzle in place. On Friday, you had a handout of a fact sheet on your desks that talked about the other fees that are currently defined in statute: fees to transmit records, manipulation of data, computer outputs, copying costs. What we are attempting to do with House Bill 1193 is create some parameters around research and retrieval fees. They are currently being charged, and depending on the circumstances, here are some examples. Colorado Springs City Government responded to a CORA request for emails among city council members for a 2-week period with a $370 estimated charge. The Colorado Springs Independent was unwilling to pay the charge and withdrew its request rather than continuing to investigate whether council members were improperly conducting public business through private emails. This bill, in my view, in my estimation, is about putting more sunshine, more light on access to these records and making it easier for the average citizen to be able to get this information, to be informed. Thank you.
Senator Lundberg.
Thank you, Madam President. I ask for permission to run a third reading amendment to the bill.
Okay. Would you care to explain why we should grant permission?
Thank you, Madam President. I'm asking for permission because this was not a bill that came through my committee, so frankly I wasn't as focused on it in the second as I should have been. And I support the bill, too. I want you to know that. But I'm trying to add some more consistency and teeth to the bill, because I believe it is an issue that I've heard, I don't know how many times, a constituent come up and say, well, you know, I tried to get that information, but they said it was $800, or they said it was this or that. And there's not a consistency, and I think there's some elements to the bill that are appropriate, but I would like to submit this amendment as a better idea, I believe, and it's the second House, and that's why I'm asking for permission in third reading to address this issue.
Question for the body is whether or not to grant Senator Lundberg permission to offer a third reading amendment. Are there any no votes? Senator Lundberg, you are granted permission. Senator Lundberg.
Thank you, Madam President. I move L008.
Senator Lundberg.
Thank you, Madam Chair, and I suspect...
Mr. Majors, I'm sorry, Senator Lundberg. Mr. Majors, would you please read Amendment L008?
Amendment L008, House Bill 1193 by Senator Lundberg, amendment revised bill, page 2, line 5, strike A, page 2, strike lines 13 to 20.
Thank you, Madam President. And again, my apologies that this is third reading, but this is the final shot we've got at this bill. And here's one of the concerns I have in the current reading of the bill is it says may impose a fee. I believe they should impose a fee on an equal basis for all entities, because there's the Colorado Open Records Act shouldn't be a mechanism whereby we pick winners and losers. It should be an information available to all. And so one of the elements within this amendment states that any fee charged for the research and retrieval must be the same for all requesting parties, whether the person requesting the records is an individual, a representative of the media, a public or private entity, or a for-profit or non-profit entity. That's one of the elements that I believe is extremely important, that is an improvement over the current form of the bill. The other is that if the document is available in a standard electronic format, that we don't charge you the fee for that. And, you know, in today's electronic world, it's just another one of those little gotchas that can be put in place in case an entity doesn't want to provide the information. If public information is to be provided to the public, it should be as free and accessible as absolutely possible. And it is for those reasons, and I'm sure there's some other discussion that's going on that will probably evoke more comments at the well. And so I submit it for the Senate's consideration.
Senator Aguilar.
Thank you, Madam President. Members, two things. First, we heard this bill in State Veterans and Military Affairs, and it actually came out unanimously. But aside from that, this is third reading. And I feel like if you have a substantive change to a bill, and this is a substantive change, that needs to be discussed during second reading. I know that Senator Kafalis worked with a huge number of stakeholders to come to the bill that was presented before us in State Affairs, and I understand Senator Lundberg's concern, but all the people who came in and testified, this was a reasonable compromise that we reached, and I don't feel that this should be supported at this point in time. I support Senator Kafalis' work and what he's done with the bill.
Senator Stebbins.
Thank you, Madam President. And colleagues, I rise in opposition to the amendment, not because of timing and procedure. Actually, the mover of the amendment is correct that this is the last vote in the second House on this bill, and if this is our last opportunity to amend the bill, unless by chance it should go to conference committee, which we don't know at this point. And so, this is a last attempt to fine-tune the language of the bill. I think it's appropriate to have this conversation, even at this stage of the proceedings. But I'm concerned about the language of the amendment. It strikes out the provisions in the last paragraph of the bill about the calculation of the research and retrieval fee, which is really the whole point of the bill. There are some language in the amendment that I support, but there's some other pieces I have questions about. And so I'm wondering if it might not be a better idea to take a step back and perhaps, with the indulgence of the bill sponsor, ask for a little more time to work on this. I'm not prepared to vote for this amendment, but I do think there's some pieces of it that have some merit. I'm a no vote on L008.
Senator Kafalis.
Thank you, Madam President. Thank you, colleagues. I appreciate the deliberation. I would respectfully ask that you vote no on this amendment, and I'll say a couple of reasons. One is that it was only just a moment ago that I saw this amendment, and I think it has implications that require a little bit more discernment. There could be some unintended consequences. This bill in its current form, there were a lot of folks who came to the table. Again, I tried to explain what the purpose of this bill is, And because I've only seen this amendment and because of some of the things that have already been stated, I respectfully ask you to vote no on Amendment L00, whatever the number is. What is it? L008. Thank you.
Senator Lundberg.
Thank you, Madam President, and I appreciate the comments from my astute colleagues who have given their counsel. I do realize that sometimes the legislative process is kind of a bumpy road. I trust that we will seek the best answers at all times. I present this to us because I do believe this is an important issue, and I trust that we will find the best solution. If this amendment is not it, then let's not be satisfied until we're fully satisfied, and leave it to the judgment of the Senate.
Senator Jones.
Thank you, Madam President. Members, I also ask for a no vote on this. What we heard in committee is that there's no perfect way to do this, but through a lot of stakeholder work, not only this year, but in previous years, they came to this compromise, which makes sense, because the other side of this coin is, as far as getting records, somebody needs to have the opportunity to get the records and have a reasonable cost for that. But if it's not paid for by the record holder, it's paid for by the regular taxpayer. And that's the balancing act that's going on here. The bill, as we adopted it yesterday, is a real positive step. It's as good as it gets. And if you adopt another amendment like this, it's like starting an extra period in a hockey game and dropping the hockey puck and seeing where it goes. I suggest that we vote no on this.
Senator King.
Thank you, President Carroll. I worry about unintended consequences. I worry about when everybody pays the same amount, and even including government entities, that any intergovernmental cooperation as far as that research and as far as those copies are concerned now is on the books, now is required for those payments to be made. And I'm wondering if it ends up costing the taxpayer more money just because it's one more bureaucratic hoop you have to jump through to make sure everything's even. I think that there are situations between counties and state, between counties and cities of copies of agreements, of that type of information, that under this law, I worry the unintended consequence is that you end up with a bureaucratic hoop that actually costs the taxpayers more money.
Senator Lundberg.
Thank you, Madam President. Good debate, good comments. I would question, however, whether the goose and the gander should not be paying the same fee. And it troubles me when we set a different standard for government entities than we do for individual citizens. I believe that it is appropriate that we have some continuity there. Remember, this is the Colorado Open Records Act. It is the statement and the policy that information that is public should be available to the public in as open a manner as practicable. The amendment and the bill, and I'll support the bill with or without the amendment, but I believe the discussion and the debate's a very important issue as well, if nothing else, to say, look, let's make sure that this is evenly applied, because the dilemma we run into, and it happens all the time, is whoever's providing the information, whoever's the gatekeeper, has the discretion of, well, I'll favor this group and I'll penalize that group by how much time it's going to take and how much cost it's going to be. We need to be very clear that the public policy for the Colorado Open Records Act is all information that is appropriately public is available to the public to the greatest extent possible. That's what I'm seeking to do. Submit an amendment, vote yes, vote no, but please send the message back to all entities within our government here in Colorado that open public records should be open and available to everyone on an equal basis, be they public or private.
Question before the body is the adoption of L008. Are there any no votes? Senator Aguilar, Senators Kafalas, Stedman, Mr. Majority Leader, Senator Nicholson, Schwartz, Senator Aguilar, I've got you. Senator Kafalas, I've got you. Madam President Pro Tem, Senators Newell, Hodge, Zenzinger, Todd, John, Kerr, Toktrop, Johnston, Jones, King, Roberts. Please add the President. With 15 ayes, 19 noes, 0 absent, and 1 excused, L008 fails. Senator Kafalas.
Thank you, Madam President. Thank you, colleagues. I renew my motion for the adoption of House Bill 1193 on third reading and final passage. I appreciate the discourse. I respectfully ask for a yes vote.
Any discussion? Senator Harvey.
Thank you, Madam President. And members, in light of the fact that that last amendment failed, that there were some issues in that amendment that I thought were good. They, especially the part that said that we had to treat like entities or different entities alike when it comes to the charges of what the clerk and recorders or whoever is charging for these research projects. I heard this bill in committee, and it was an interesting debate. On the one, there's two different sides of it. On the one side, government should be transparent. They should readily keep and provide documentation of the business that they do on behalf of all of us, the citizens, and they should provide that information to the citizens for free because we are paying them to do the work that they do, and they should readily have all of that information that we pay them to do. So why shouldn't they pay? Why should we pay again to have them provide us that documentation? Valid argument. But then on the other side, you have entities that come in and do very, very broad KORA requests. The explanation was given from the Attorney General's office that a KORA request was given to the state of Colorado by a national media outlet saying, give us all of your correspondence from the state of Colorado to the federal government. That was the request. Can you imagine how unbelievably burdensome that would be to meet that request? After a few discussions with the network about how burdensome that would be to meet that request, it came down to give us all of the documentation of correspondence between the state of Colorado and the federal government regarding marijuana implementation, legislation implementation. That's a little more narrow of a discussion. But you have those situations all the time. So yes, we should be transparent. We should be able to give the citizens of the state of Colorado information on the business that we do. And normally that shouldn't take more than an hour. And under this bill, we are saying that you will only charge $30. You will not charge anything inside that first hour of research, because normally you can get that information. But if it's beyond that first hour, then it will only be $30. I think that's good public policy. I think under most circumstances, we will be able to provide the citizens clarity, transparency, and provide them the documentation that they seek within that first hour And most of the time, that information is electronically transferred and collected and distributed, and we don't charge anything for that. In statute, we already say that you will not charge anything for that. But if it is going to be an incredibly burdensome request, like a media organization saying, provide us all correspondence on references to marijuana to the federal government, that's going to be a costly, expensive, burdensome request. And I believe that the requestor on something that broad and that burdensome should not be looking to you and me, the taxpayers, to have to pay government agencies to have to fulfill that request. I think it's a good compromise between transparency and abusive core requests from media outlets that are on a hunting expedition just to try to find something to go after the government on or an elected official on. And I know you and I are cored regularly on our per diems, on what we are putting on our reimbursements, and they don't know what they're looking for. They are just looking for something to come at you on as a gotcha. Is that really what CORA is all about? Maybe it is. Maybe we want to have that kind of transparency, but if it is just a fishing expedition, I don't think the taxpayers of the state of Colorado should have to pay for that fishing expedition. I believe the individuals making that request should be. So I think this is a fine line between transparency and protecting the taxpayers at the same time. So I think it's a good bill, and I would ask for an aye vote.
Senator Kafalis.
Thank you, Madam President, and thank you, colleagues. You got to love the legislative process. I move for permission for a third reading amendment.
The motion is to grant Senator Kafalis permission for a third reading amendment. Senator Kafalis, you want to explain your request?
Thank you, Madam President. And colleagues, once again, the discourse, the deliberation has been interesting. I am listening as everything moves fast, but I have listened, and I'm offering this amendment because I want to capture a portion of L008 that I think we can all agree upon.
Question is to grant permission. All those in favor say aye. Opposed, no. Ayes have it. Senator Kafalis is granted permission to offer a third reading amendment. Mr. Majors, would you please read Amendment L009?
Amendment L009, House Bill 1193.
Senator Kafalis.
Thank you, Madam President. I move L009.
Thank you. Please proceed.
Thank you kindly, Madam President. Colleagues, Amendment L009 basically keeps the last part of the previous amendment, which reads, any fee charged for the research and retrieval must be the same for all requesting parties, whether the person requesting the records is an individual or representative of the media, a public or private entity, or a for-profit or non-profit entity. That is the amendment. I ask for your support.
Senator Harvey.
Thank you, Madam President. And I would like to thank Senator Kafalis for bringing this amendment forward. This was an important part of the Lundberg amendment that I thought should have been approved. There was testimony in committee about how there was anecdotal evidence that a county was charging for the very same information, different parties a different fee, because they liked one of the parties but didn't like one of the other parties. And I think we can all imagine how a frustrated government employee might do that. And that's totally and completely inappropriate. I think that this amendment is a great amendment in addition to the bill to make sure that we are treating all citizens alike, whether you like them or not.
Senator Lundberg.
Thank you, Madam President. Good amendment. Vote yes.
Any further discussion on L009? Question before the body is the adoption of the amendment. Are there any no votes? Senator Jones. With 33 ayes, 1 no, 0 absent, and 1 excused, L009 is adopted. Question before the body is the adoption of House Bill 1193 as amended. Are there any no votes? Senator Balmer, are you a no? Senator Balmer. With 33 ayes, 1 no, or Senator Marble? With 32 ayes, 2 noes, 0 absent, and 1 excused, House Bill 1193 is adopted. Co-sponsors: Senator Toktrop, Senator Kerr, Senator Schwartz, Mr. Majority Leader, Madam President Pro Tem, Senator Nicholson. Co-sponsors: Senator Crowder. Please add the President. Senator Lundberg. Senator Herpin. Mr. Majors, would you please read the title to House Bill 1210?
House Bill 1210 by Representative Roan, Senator Roberts, concerning a requirement that a state agency enter into an intergovernmental agreement with the county to address wildland fires affecting certain state lands located within the county.
Senator Roberts.
Thank you, Madam President. I move for the adoption of House Bill 1210 on third reading and final passage.
Any discussion? Question is the adoption of 1210. Are there any no votes? Senator Marble. With 33 ayes, 1 no, 0 absent, and 1 excused, House Bill 1210 is adopted. Co-sponsors: Senator Crowder, Senator Nicholson, Senator Kerr, Madam President Pro Tem, Senator Kafalis, Senator Newell, Senator Todd. Mr. Majority Leader, Senator Schwartz. Please add the President. Mr. Majors, would you please read the title to House Bill 1047?
House Bill 1047 by Representative Becker and Senator Guzman, concerning restrictions on the publishing of basic identification information on commercial websites.
Senator Guzman.
Thank you, Madam President. I move House Bill 1047 on third reading and final passage and ask for an aye vote.
Any discussion? Question is the adoption of House Bill 1047. Are there any no votes? Senators Crowder, Marble, Baumgartner, Harvey, Grantham, Brophy, Renfro, Hill, Scheffel. Mr. Minority Leader. Senator Lambert. With 23 ayes, 11 no, 0 absent, and 1 excused, House Bill 1047 is adopted. Co-sponsors: Senators Kafalis, Nicholson, Aguilar, John. Mr. Majority Leader. Senators Kerr, Jones, Schwartz, Newell, Todd, Zenzinger, Johnston, Mr. Majors, would you please read the title to House Bill 1274?
House Bill 1274 by Representatives Kraft, Harper, and Holbert, and Senator John, concerning the modification of certain limitations on the managers of a bank chartered by Colorado.
Senator John.
Thank you, Madam President. I move House Bill 1274 on third reading, final passage, and ask for an aye vote.
Any discussion? Question for the body is the adoption of House Bill 1274. Are there any no votes? With 34 ayes, 0 no, 0 absent, and 1 excused, House Bill 1274 is adopted. Co-sponsors: Senator King, Mr. Majority Leader. Mr. Majors, would you please read the title to Senate Bill 156?
Senate Bill 156 by Senators Kafalis and Heath and Representative Lee, concerning a requirement that a public benefit corporation file an annual report.
Mr. Majority Leader.
Thank you, Madam President. I move we lay over Senate Bill 156 until Thursday, March 27th.
For the motion, all in favor say aye. Aye. Opposed? The ayes have it. Senate Bill 156 will lay over till Thursday, March 27th. Mr. Majors, would you please read the title to House Bill 1080?
House Bill 1080 by Representatives McLaughlin and Coram and Senator Roberts, concerning a sales and use tax exemption for the Colorado Ute
Senator Roberts.
Thank you, Madam President. I move for the adoption of House Bill 1080 on third reading and final passage.
Any discussion? Question is the adoption of House Bill 1080. Are there any no votes? Senators Balmer, Marble, Baumgartner. These are no votes on House Bill 1080. Okay. With 31 ayes, 3 noes, 0 absent, and 1 excused, House Bill 1080 is adopted. Co-sponsors, Senator Stedman, Madam President Pro Tem, Senators Nicholson, Kafalas, Newell, Aguilar, Crowder, Herpin, Todd, Kerr, Schwartz, Harvey, King. Mr. Majority Leader. Mr. Majority Leader.
You want a moment?
Mr. Majority Leader.
Thank you, Madam President. Move we proceed out of order for a moment of personal privilege.
We'll stand in brief recess.
I just wanted to do that reconsideration of 1089.
The Senate will come back to order. Senator Brophy.
Thank you, Madam President. Having voted on the prevailing side yesterday on House Bill 1089, I would ask for reconsideration of the final action on House Bill 1089. That is a license plate bill that we voted on yesterday.
Yeah, this is yours.
Members, we're going to stand in a recess because where this is in the enrolling process will determine whether it's reconsideration or actual recall that is needed procedurally. The Senate will stand in recess.
No.
come back to order. Senator Brophy.
Thank you, Madam President. I will withdraw the motion to reconsider and make a motion instead to recall House Bill 1089 from the House.
The motion before the Senate is to recall, okay, notice of recall will be sent over to the House on House Bill 1089. Members, that means that will show back up on the calendar for third reading. General orders, second reading of bills, calendar, Senator Nicholson.
Thank you, Madam President. I move the Senate resolve itself to the Committee of the Whole for the consideration of the general orders, second reading of bills calendar.
You've heard the motion. All in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself into a committee of the whole for purpose of considering general orders, second reading of bills calendar, and Senator Nicholson will take the chair.
The committee will come to order and the court rule is relaxed. Mr. Majors, would you please read the title to House Bill 1136?
House Bill 1136 by Representative Primavera and Senator Todd concerning exempting a continuing professional education program that is approved by a state professional licensing board from regulation by the Division of Private Occupational Schools in the Department of Higher Education.
Senator Todd. Thank you, Madam Chair, and I move House Bill 1136. To the bill, Senator Todd. Thank you, Madam Chair. This bill exempts certain qualifying nonprofit occupational schools from oversight by the Department of Higher Education. It's anticipated to result in really a slight reduction in workload for the the Division of Private Occupational Schools. The bill was heard in education and probably would have gone to consent calendar, but we had a couple of members absent, and so out of respect for them, we wanted to allow for any further discussion on the floor. Is there any further discussion? Seeing none, the motion before the body is the adoption of House Bill 1136. All those in favor say aye. Aye. Opposed say no. The ayes have it, and the bill passes. Mr. Majors, would you please read the title of House Bill 1271?
House Bill 1271 by Representative Melton and Senator Newell concerning extending a mental health provider's duty to warn to include specific entities that if purposefully damaged or attacked as a result of a mental health patient's violent behavior will jeopardize public health and safety.
Senator Newell.
Thank you, Madam Chair. I move House Bill 1271.
To the bill, Senator Newell.
Thank you. Members, this passed unanimously out of the House and actually unanimously out of our committee as well. The purpose behind House Bill 1271 is to expand upon our current immunity with the duty to notify for mental health therapists or mental health providers when a threat is made toward a specific location by a patient. Following the Aurora Theater shooting in 2012, it is unclear if our current statute would have allowed the therapist treating the suspect to alert law enforcement or the movie theater. This is because our current law only provides immunity with the duty to notify when a threat is made toward a specific person or persons. So the details of the bill are that it adds person or persons, including those identifiable by their association with a specific location or entity. The bill also cleans up current language in order to incorporate person-first language. It was, actually, I think, Senator Stedman and Representative Baumgartner's bill a couple of years ago, meaning that we identify people first and then whatever their condition is. So it cleans up that language as well. And I ask for an aye vote.
Senator Lundberg.
Thank you, Madam Chair. Members, I did support this bill, and I want to explain some of the particulars because I'm not fully satisfied with what this section of law does, honestly, because it's that piercing that veil of patient doctor privilege when it comes to a mental health provider, and that's what the law says and does today. And it's those circumstances when there's a life-threatening situation that the mental health provider, the psychiatrist or psychologist, is aware of a circumstance that's just that needs immediate attention. And this bill expands that to specific, identifiable. Somebody says, I'm thinking of doing XYZ at blah 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 shopping center or something like that. That it expands it to allow the reporting, and relieving some of the civil liability that provider would have. In other words, they couldn't come back and sue them on it. Now, having said that, there's one portion of the bill that does trouble me, and it's not the bill per se because it's in the law today, that I do want to point out, and I did have questions in committee as to whether changing the dynamics on when you can report what might raise the incidence of reporting someone or putting them on a 72-hour hold. And that's, if you look at the engrossed bill version on page 3, lines 24 and following, the provisions of this, and again, this is simply repeating what the section of the law already says today. The provisions of this section do not apply to, meaning that it's a double negative in here. Essentially, you are do not apply to the negligent release of a patient from any mental health hospital or ward, or to the negligent failure to initiate involuntary 72-hour treatment and evaluation after a personal patient evaluation determining that the person appears to have a mental illness and as a result of the mental illness appears to be an imminent danger to others. It's that term of negligent. What is the level of what is a negligent action on the part of the mental health provider in just ignoring the obvious that this person really needs to be put on a 72-hour hold or continued in a hospital setting? And the reason this is so vitally important is a 72-hour hold is a direct violation of the personal freedom of that citizen. They have not broken the law anywhere. But we have this provision within our laws that says several people, not only mental health providers, but policemen and medical doctors, and I believe there are a couple of other categories of professions in there that allow them to say XYZ person needs to be held against their will and evaluated for their mental capacity because they are an imminent danger to themselves or to someone else. That's a very serious issue. And I don't want, and I come down to the mic partially to just state for the record that this bill, House Bill 1271, does not change the standard of what is negligent activity on the part of the mental health professional. I don't want any mental health professional to think, oh, well, because 1271 became law, I have to be more apt to put somebody on a 72-hour hold. I should hope after the discussion we've had over this bill that it would be the exact opposite, that people would realize once again what a significant violation of the citizen's individual rights a 72-hour hold is. And it should only be exercised as the last resort. But this bill does state, and that includes information about somebody thinking, not more than thinking, telling them, the mental health professional, that they're intending on doing some significant damage at some specific location. Okay, I get that. There's an appropriateness to intervene at that point. But never, ever should we construe this to then therefore be sort of the general attitude that we're going to rush into more circumstances and control citizens more because of maybe something less than the specific requirements within this bill. I hope I've made myself clear. Yes, I'm voting for the bill, but yes, I am very troubled by the 72-hour hold concept in the first place. Let it be the last resort in every circumstance. And unfortunately, I'll say this too, it isn't. I've heard far too many examples of where it was the first thing that the doctor or the policeman or the whoever, we just put them on a 72-hour hold because we wanted to get them out of there. No, that's not good enough. That was a violation of the law, and I don't want that to occur ever.
Senator Harvey.
Thank you, Madam Chair. And I wish I had had the privilege of sitting in on this committee hearing, because this is a very important issue of law and of clinical practice when you are talking about a client and the medical professional and what is privileged and what is not privileged. And I am concerned about a couple of things. One, what will be the effect? I worry about having a chilling effect on people who need to have mental health care, not wanting to go to their doctors because they feel that they will be reported on if they do seriously need help and they are seeking medical help, mental health help, and will they not because they think that the doctors will be reporting them. And that's one issue. And then on page 3, line 8, it says, when there is a duty to warn and protect under the provisions of this paragraph. I would like some understanding about what that means. One, I hear you say that they're not being required to report, but then I read that line and it makes me wonder, are we saying in this bill that they do have a duty to report? And under what circumstances do they have a duty to report? And are we then putting the physicians in a position where they are going to have to breach that provider-client privilege that is currently in place? This is a very complicated issue, and I'd love to have a little more clarification on those issues so that the citizens of Colorado understand exactly what we're doing with this bill.
Senator Hill.
Hey, Linda, do you want to respond to any of that stuff that he just went?
I just thought I'd do it all at once.
Okay.
Unless you do it.
Sure. Thank you, Madam Chair. Colleagues, I supported this bill, and I just want to explain some of that. I had some concerns going into the committee hearing as well. My understanding is this does not change any of the duty to warn requirements, but it actually increases and gives more freedom to the mental health professionals out there, knowing that they cannot be held civilly liable if they feel a professional duty to act under the context of the law. And if there is a threat to a specific person, a specific place, a specific location, this actually empowers our mental health professionals to do what we say we want them to do. That's to be someone that we trust, to provide that kind of counsel, and also to do under their professional duty what they see as necessary. So to me, this supports my principles of empowering the professionals in our community to make those decisions without threat from the government. And under this case, we're taking away some of that civil liability. I also had concerns, that's the first section of the bill. I also had concerns on the second section of the bill about negligence in releasing patients. And I think we still have some work to do on this front. While it is in the language of the bill, because they were rearranging, the drafter was rearranging some of current law, this is already in current law. And so rather than address it in the context of this bill, some of my concerns that already exist in law, I will support it as it stands. But I do want to note, going forward, I would like us to take very seriously whether or not we are creating undue incentive for doctors, for hospitals to commit, to make these involuntary 72-hour commitments simply for the fact they want to make sure they're not held negligent for one reason or another. And as a military officer, as someone who's watched many of these heroes from Iraq and Afghanistan and other places in the world come back, we need to make sure we have a place, whether it's professionals, whether it's counselors, whether it's mental health professionals, a place where people can come and share their struggles as they're readjusting to normal life here in the United States, a place where they know they can speak about whether it's some of the haunting dreams they have, some of the things they have lived through, that they have a place, and that we do not have law that's written in some ways against them, incentivizing these involuntary 72-hour holds just as a way for hospitals and mental health professionals to cover their ass, is for lack of a better term, but just to make sure that our returning soldiers and anyone else struggling with some of these mental health issues have a chance to get the protection, to get the counseling they need without us incentivizing through this wording on negligence. So I do support the bill, and I encourage you to as well.
Senator Crowder.
Thank you, Madam Chair. I heard this also in committee. On the 72-hour hold, what we're trying to do is we're trying to build, and I'm going to be supportive of this bill that we have, but the 72-hour hold is not something that's done at this point in time because the 2765 designated hospitals are not in place. There's a lot of confusion from HHS on this, so I think we need this bill in place to start building on where exactly we need to be concerning the 72-hour hold. We have to start somewhere, although the implication is everything is pretty well set. Well, it's not. But we can build on this bill, and we can make this work, and we can. Our issues are beds in hospitals and whatnot, but it goes beyond just the entity of the direction of what the person is directing us to. It could be self-inflicted situation where we need to look at. There's a lot of situations on this that have not been tied down or worked out yet. But I think if we can get this through, I think we can build a network that possibly could make it work. So I'm supportive of this, and I ask for an aye vote.
Senator Newell.
Thank you, Madam Chair, and thank you, members, for your support. I will clarify those questions that were addressed up here. One is that the duty to notify is when a serious threat of imminent physical violence is made against a specific person or persons, and this just expands it to include those in a facility, location, entity. This bill is only about notification. It is not anything to do with committal. It's only about notification. And so we did talk about some of the issues in our committee that were addressed earlier, but I do want to assure people that this particular bill does one small thing, which is just expanding the to locations or entities. And with that, Madam Chair, I ask for an aye vote.
Is there any further discussion on House Bill 1271? Seeing none, the motion before the body is the adoption of House Bill 1271. All those in favor say aye. All those opposed, no. The ayes have it, and the bill passes. Mr. Majors, would you please read the title of House Bill 1186?
House Bill 1186 by Representative Schaefer, Senator Aguilar, concerning the release of medical records to a person other than the patient and in connection therewith setting reasonable fees to be paid for the release of the medical records.
Majority Leader Heath.
Thank you, Madam Chair. I move we lay over House Bill 1186 until tomorrow, March 26th.
Motion before the body is to lay over House Bill 1186 until tomorrow. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Bill will lay over. Majority Leader Heath.
Thank you, Madam Chair. I move we rise and report.
Motion before the body is to rise and report. All those in favor say aye. Those opposed, no. The ayes have it, and the committee will rise and report.
The Senate will come back to order. Senator Nicholson.
Thank you, Madam President. The committee has met and had 3 bills under consideration. Mr. Majors, would you please read the report?
March 25th, 2014, Madam President, your committee will basic reports that are consideration of the following attached bills being a second reading thereof makes following recommendations thereon. House Bills 1136 and 1271 passed on second reading and ordered revised, placed on the counter for third reading and final passage. House Bill 1186 laid over till March 26, 2014, retaining its place on the calendar.
Senator Nicholson.
Thank you, Madam President. I move for the adoption of the report.
Question for the body is the adoption of the Committee of the Whole report. Are there any no votes? With 34 ayes, 0 no, 0 absent, and 1 excused, the Committee of the Whole report is adopted. House Bill 1136, House Bill 1271 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. House Bill 1186 laid over until March 26th, then retaining its place on the calendar. Consideration of House amendments to Senate bills. Mr. Majors, would you please read the title to Senate Bill 54?
Senate Bill 54 by Senator Balmer and Representative Pabon concerning the ability of an alcohol beverage licensee to petition the licensing authority to pay a fine in lieu of a license suspension ordered by the licensing authority.
Senator Balmer.
Thank you, Madam President. Madam President, I move that the Senate concur with the House amendments to Senate Bill 54.
Okay. Please proceed with your explanation.
Thank you, Madam President. Members, the House actually, a technical amendment was brought to the attention of Representative Pabon, who is the House sponsor. CML realized that with the changes that we were making in the bill, we forgot to also make that same change in another place in the statute. So all we're doing with this, it seems more substantive than it is. It's just keeping that consistent with the other changes that we're making in the bill so that we give local governments more flexibility to work with someone who has violated the liquor laws. So it's really, it looks like it's not technical, but it is technical. So I ask for concurrence in the House amendment.
Any discussion? The motion before us is for the Senate to concur with House amendments to Senate Bill 54. Are there any no votes? With 34 ayes, 0 no, 0 absent, and 1 excused, the Senate concurs with House amendments to Senate bills. Senator Balmer.
Thank you, Madam President. I move for the repassage of Senate Bill 54, and our esteemed Assistant Minority Leader asked me how this relates to dogs, and this bill has nothing to do with dogs, but I hope that you'll pass it anyway. Thank you.
The question for the Senate is repassage of Senate Bill 54. Are there any no votes? With 34 ayes, 0 no, 0 absent, and 1 excused, Senate Bill 54 is readopted. Additional co-sponsors. Mr. Majors, would you please read the title to Senate Bill 98?
Senate Bill 98 by Senators Zenzinger and Representatives Foote and Schaefer concerning clarifications to statutory language on crimes against at-risk elders.
Senator Zenzinger.
Thank you, Madam President. I move that the Senate concur with House amendments to Senate Bill 98.
Okay, please proceed with your explanation.
This bill passed through the Senate unanimously, it passed through the House unanimously, but unfortunately, there was a potential appropriation clause that was in the bill that normally gets taken out when it goes to appropriation, but because there wasn't an appropriation necessary, it didn't go to appropriations, so that clause was not taken out. So the House went ahead and removed it on third reading.
Any discussion? The motion before us is for the Senate to concur with House amendments to Senate Bill 98. Are there any no votes? With 34 ayes, 0 noes, 0 absent, 1 excused, the Senate concurs with House amendments to Senate Bill 98. Senator Zenzinger.
Thank you, Madam President. I move for the readoption of Senate Bill 98.
Any discussion? Question is readoption of Senate Bill 98. Are there any no votes? With 34 ayes, 0 noes, 0 absent, and 1 excused, Senate Bill 98 is readopted. Additional co-sponsors. Consideration of governor's appointments, consent calendar. Mr. Majors, would you please read the appointments on the consent calendar?
Members of the Private Occupational School Board for terms expiring July 1st, 2014, Joseph James Wolf of Arvada, Colorado, representative of the general public who is employed by a lending institution located in Colorado and is familiar with the Colorado College Access Network and occasioned by the resignation of Earl F. Douglas of Lakewood, Colorado, appointed. Rochelle G. Krovitz of Greenwood Village, Colorado, representative of the general public and occasioned by the resignation of Winifred S. Rovick of Glenwood Springs, Colorado, appointed. For a term expiring July 1st, 2015, Richard Samacula of Centennial, Colorado, representative of a private occupational school and occasioned by the resignation of Jennifer Linda Sprague of Thornton, Colorado, appointed. Members of the Board of Trustees for the University of Northern Colorado, for a term expiring December 31st, 2015, Kevin Walter Aaron of Morrison, Colorado, to serve as a Republican and occasioned by the resignation of Susan E. Carparelli of Highlands Ranch, Colorado, appointed. Effective December 31st, 2013, for term expiring December 31st, 2017, Richard L. Monfort of Greeley, Colorado, a Republican, reappointed. Christine M. Scanlon of Dillon, Colorado, a Democrat, appointed. Members of the Solid and Hazardous Waste Commission for terms expiring August 1st, 2016, Cameron L. Garcia of Florida, Colorado, to serve as a representative from the regulated community and as a Republican, appointed. Christopher J. Newman of Denver, Colorado, to serve as a representative of the academic community and as a Republican, reappointed. Members of the Colorado Tourism Office Board of Directors for a term expiring June 1st, 2015, Sonia Quinn Riggs of Denver, Colorado, representative of the food, beverage, and restaurant industry, and occasioned by the resignation of Lawrence R. DePascal of Greenwood Village, Colorado, appointed. For terms expiring June 1st, 2017, Barbara Jean Bowman of Grand Junction, Colorado, serves as a representative of cultural event and facility groups, appointed. Courtney Lee Frazier of Parker, Colorado, to serve as an at-large member from tourism-based industries and from a small community, and occasioned by the resignation of Ann Catherine Klein of Durango, Colorado, appointed.
Mr. Majority Leader.
Thank you, Madam President. I move for the confirmation of all the appointments on the consent calendar, including members of the Private Occupational School Board, members of the Board of Trustees for the University of Northern Colorado, members of the Solid and Hazardous Waste Commission, and members of the Colorado Tourism Office Board of Directors.
Is there any discussion on any of the appointees on the consent calendar? Seeing none, the question for the body is the confirmation of those appointees listed. Are there any no votes on any of the appointments on the consent calendar? With 34 ayes, 0 noes, 0 absent, and 1 excused, Joseph James Wolf, Rochelle G. Krovitz, and Richard Samacula are confirmed as members of the Private Occupational School Board. With 34 ayes, 0 noes, 0 absent, and 1 excused, Kevin Walter Ahern, Richard L. Mumford, and Christine M. Scanlon are confirmed to the Board of Trustees for the University of Northern Colorado. With 34 ayes, 0 noes, 0 absent, and 1 excused, Cameron L. Garcia and Christopher J. Newman are confirmed to the Solid and Hazardous Waste Commission. With 34 ayes, 0 noes, 0 absent, and 1 excused, Sonia Quinn Riggs, Barbara Jean Bowman, Courtney Lee Frazier are confirmed to the Colorado Tourism Board of Directors. Consideration of governor's appointments, Senator Aguilar.
Thank you, Madam Chair. I move for the appointment of Randall Mark Wiener of Boulder, Colorado, to serve as a member of the public on the Solid and Hazardous Waste Commission.
Any discussion? Senator Lundberg.
Thank you, Madam President. Members, I voted against this gentleman who is being appointed in committee, and it's because of the questions that I asked and the answers that were not satisfactory. In fact, this is the Solid Waste and Hazardous and Solid Waste Commission, I believe it is. And so they deal with trash, with landfills. And there were 3 people who were being interviewed, 2 of which we already unanimously approved. But the question of the disposal of paint came up. And I didn't try to review the debate on that particular bill, except for the real troubling point here, which is, what's it going to cost? What sort of cost considerations are they going to put in place? Are they going to take into account when making the decisions on how waste is handled in the state of Colorado? And I asked the question of all 3 who were before us, and the other 2 gave some indication that that was a factor. But this particular gentleman did not, and I asked him twice. And he didn't really directly answer the question, but he gave this much of an answer, and that is, well, it's going to be expensive. I am not satisfied with that type of an answer. Now, it may seem like a trivial issue, trash, waste, landfills, but in fact, talk to somebody who has, let's say they're doing some renovation on their house and they have to take a couple of pickup loads of trash to the dump. It is a very expensive process. And I believe it's largely because of the attitude that I saw demonstrated by this gentleman who has an incredible background as an attorney working in the area of waste management. Can't say that I agree with at least the one example that was brought up as to what he was advocating for, but it's quite obvious that from his answer that cost was of no consequence to him. That should not be. The people of Colorado cannot afford to live the lives that they're trying to live right now because of the costs we put on them, and this is going to be one more step. So I believe we should tell the governor, no, this is not an appropriate member for your commission on waste management. You need to find people who are going to be sensitive to the cost considerations as well as all the other considerations when it comes to waste management, but that shouldn't be it's just going to cost whatever. And I asked the guy twice. I wanted to make sure I got the clear picture of what he was saying, and what he was saying, the best I could determine is I couldn't care less what it costs. It's going to drive the cost up higher? Well, tough. Well, that earned a no vote for me.
Senator Hill.
Thank you, Madam President. Colleagues, I too oppose the nomination of Mr. Wiener. Many of us know in here that they're not simple issues. There are not one-sided issues that we face in here, and part of our task is to reconcile the many different competing needs and interests and demands of 5.2 million people here in Colorado. And through the questions and through the answers that we received in committee, colleagues, I became very convinced that Mr. Wiener was not interested in balancing this debate and balancing these questions. Rather, he was interested in bringing his personal and political agenda and use this seat as a way to advance that cause. And to me, that is not the role of these committees. It is not the job of these appointees. Rather, it is the job to serve. And so I cannot support someone going forward who shares that vision for this role of service as a chance to advance their own agenda.
Any further discussion? Senator Aguilar.
Thank you, Madam President. I'll defer to the Majority Leader.
Mr. Majority Leader.
I'm going to ask for Senatorial 5.
We'll take a Senatorial 5. The Senate will come back to order. Mr. Majority Leader.
Thank you, Madam President. I move we lay over the appointment of Mr. Weiner until Thursday, March 27th.
For the motion, all in favor say aye.
Aye.
Opposed, no. Ayes have it. The appointment of Randall Mack Weiner will lay over till March 27th. Message from the House.
March 25th, 2014, Madam President, the House has adopted and returned to with Senate Joint Resolution 11. The House has passed on third reading and transmitted the Revised Statute House Bills 1312 and 1307. The House has passed on third reading and transmitted the Revised Statute House Bill 1295 as amended. The House has passed on third reading and returned to with Senate Bill 22. In response to the request of the Senate for the recall of House Bill 1089, the bill is transmitted herewith.
Committee reports.
March 24, 2014, Committee on State Vendors and Military Affairs, after consideration of the Mayor's Committee recommends following Senate Bill 157 be referred favorably to the Committee on Appropriations. March 24, 2014, Committee on State Vendors and Military Affairs, after consideration of the Mayor's Committee recommends following Senate Bill 153 be referred favorably to the Committee on Appropriations.
Announcements. Senator Todd.
Thank you, Madam President. And just a reminder, those of you that would like to join the Transportation Committee today to visit DIA, we will be meeting on the east side of the Capitol, right along Grant, at 10 till 2. So 150. And make sure you've got your hard-soled shoes. Thank you very much.
Thank you. Senator Jones.
Yes, I just want to remind members of the weed and pest control reception this afternoon. We're not talking about legislators here. We're talking about weeds and pests. You know, you might think of this as a rural issue, an ag issue. It's not just that. It is, and it's not just what happens in your yard and your lawn. But if you go out hiking, you'll notice there, once you start knowing what weeds look like, you will see a lot of them out in our natural lands. And it's also an issue with fire. Where the weeds come back in. The Dalmatian toadflax, I'm told, in the High Park fire area is quite bad. So these are the people that help us manage those weeds. So it's tonight, March, let's see, from 4:30 to 7:30 at Katie Mullins.
Senator Aguilar.
Thank you, Madam President. Could I ask for 2 moments of personal privilege?
Yes, granted.
First of all, colleagues, this is the anniversary of Medicare Advantage plans, and as any of you who know Colorado Medicare beneficiaries, these have come out to give them a great opportunity to have their care managed and their medication managed, and we're hopeful that the Medicare Advantage plans will continue for our seniors in the future. And so in honor of that, I'm going to give them a tribute on that. The second piece of information I wanted to share with you is one of the jewels in my district is Colorado Heights University on South Federal Boulevard, and they are currently offering international business degrees for foreign students. And tomorrow morning between 7:30 and 9, they're going to be in front of the old Supreme Court chambers dressed in their traditional dress, and these countries represented will include Kazakhstan, Paraguay, Ghana, Taiwan, Gabon, amongst others. And I'd encourage you to join us for breakfast tomorrow morning in front of the old Supreme Court chambers at 7:30.
Senator Schwartz.
And thank you, Madam President. Now, you do remember tomorrow is the best lunch of the year, and that's Egg Day at the Capitol. We will have down there our celebrity chefs. The governor will kick it off at 11:30. We're going to have all of our food producers in the state. It's a great day to recognize the bounty that Colorado grows, creates, sells, and drives our economy. So don't forget, downstairs, West Foyer, 11:30, and come for the best lunch of the year.
Message from the reviser.
March 25th, 2014, we hear with transmit without comment House Bill 1307 and 1312 without comment as amended House Bill 1295.
Mr. Majority Leader.
Thank you, Madam President. Just a couple of announcements on committees. The Education Committee tomorrow will hear testimony only on Senate Bill 167. That's the Education Committee tomorrow on Senate Bill 167. In local government, House Bill 1130 will not be heard in local government today and will be postponed until April 8th. So with that, Madam President, I move that the Senate adjourn till 9 a.m. Wednesday, March 26th.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. The Senate will adjourn until 9 a.m. Wednesday, March 26th.